I realized something was catastrophically wrong when I found a manila folder wedged behind my office filing cabinet at 2 in the morning, containing emails that would unravel everything our homeowners association had built over the past 18 months. My name is Marcus Irving, and I am a mechanical engineer who moved to Riverside Meadows, a planned community outside Phoenix, Arizona, 3 years ago. The neighborhood seemed perfect at first. Clean streets, well-maintained common areas, and reasonable HOA fees. My wife Elizabeth had just gotten a promotion at her marketing firm, and we thought this suburban paradise would be the ideal place to raise our 2 kids. But paradise has a way of rotting from the inside out when nobody is paying attention to the foundation. The trouble started when Hartfield Development Corporation announced plans to build a massive commercial complex right on the edge of our residential community. The project would bring heavy traffic, noise pollution, and a significant decrease in our property values. Our HOA board, led by President Deborah Mathens, immediately hired an attorney named Gregory Walsh from Walsh & Associates to fight the development. We all chipped in for a special assessment of $800 per household to fund the legal battle. Nobody complained because we all had something to lose. I got involved in the fight 6 months ago when Deborah asked me to serve on a special committee to review documents and coordinate with our attorney. I've always been detail-oriented, probably an occupational hazard from years of checking engineering specifications. My role was mostly administrative, organizing community meetings, distributing updates to residents, and keeping track of our legal expenses. Nothing fancy, but I took it seriously because this fight mattered to everyone in Riverside Meadows. The committee met every Tuesday evening in the community center, a bland beige building with fluorescent lights that buzzed like angry wasps. There were 5 of us, me, Deborah, a retired teacher named Patricia Coleman, a software developer named Victor Hayes, and a real estate agent named Sandra Mitchell. Gregory Walsh would join us occasionally, usually to deliver updates that sounded impressive, but never seemed to result in actual progress. I started noticing inconsistencies about 3 months into the legal battle. Gregory would tell us he had filed motions that I could not find in the public court records. He claimed to have scheduled hearings that never appeared on the court calendar. When I asked him about it, he would wave his hand dismissively and say something about procedural delays or administrative backlogs. His explanations always sounded plausible enough that I let it slide, but doubt had started gnawing at the back of my mind. The manila folder changed everything. I had been working late in my home office, going through our financial records because something about the legal bills bothered me. The numbers added up correctly, but the timing felt off. Gregory had submitted an invoice for $12,000 for work performed in March, but I distinctly remembered him being absent from multiple meetings that month, claiming he was handling our case in court. When I stood up to stretch, my foot kicked something wedged behind the filing cabinet. I pulled it out and found the folder, which must have fallen back there weeks ago when Elizabeth had borrowed my office to work on a presentation. Inside were printed emails, and the moment I started reading, my blood went cold. The emails were between Gregory Walsh and someone named Robert Kincaid at Hartfield Development Corporation. They discussed strategy, timelines, and most damning of all, how to string along the Riverside Meadows HOA while ensuring the development project moved forward without meaningful opposition. The dates on the emails ranged from 2 months before we even hired Gregory through last week. I sat back down, my hands shaking as I read through every single page. Gregory Walsh was not just failing to represent us adequately, he was actively working for the developer we had hired him to fight against. The conflict of interest was not just unethical, it potentially voided every legal filing he had made on our behalf. Every motion, every response, every piece of paperwork submitted to the court under his name might be tainted by his dual representation. I needed to verify this information before I took it to anyone else. At 2:30 in the morning, I was not thinking clearly, but I knew enough to understand that making accusations without solid proof would backfire spectacularly. I scanned every page of the emails and saved them to 3 different locations: my computer, a USB drive, and a cloud storage account. Then, I spent the next 2 hours researching Gregory Walsh online, digging through every public record I could access. What I found made the situation even worse. Walsh and Associates had represented Hartfield Development Corporation on multiple previous projects across Arizona. He had successfully defended them against neighborhood associations in Tucson, Scottsdale, and Flagstaff. The man had a track record of crushing residential opposition to commercial development, and we had handed him our entire legal strategy, our financial resources, and our trust. By the time the sun came up, I had assembled a comprehensive file of evidence: the emails, screenshots of Walsh and Associates' website showing Hartfield as a client, court records from previous cases, and a detailed timeline of suspicious activities during our own legal battle. I also discovered that several of the filings Gregory had claimed to submit were either never filed or were filed incorrectly, ensuring they would be dismissed on procedural grounds. Elizabeth found me at the kitchen table at 6 in the morning, surrounded by papers and nursing my fourth cup of coffee. She took one look at my face and knew something serious had happened. I explained everything while she made breakfast, watching her expression shift from confusion to anger to something close to despair. We had paid that $800 assessment just like everyone else in Riverside Meadows. We had believed we were fighting for our community, our home values, and our quality of life. Instead, we had funded our own defeat. I called Deborah at 7, knowing she was an early riser. She answered on the second ring, and I could hear the tension in her voice when I told her we needed to meet immediately. She suggested the community center, but I insisted on a more private location. We settled on a coffee shop in downtown Phoenix, far enough from Riverside Meadows that we would not run into neighbors who might overhear our conversation. Deborah arrived looking every bit the suburban HOA president, perfectly styled blonde hair, designer athleisure wear, and an oversized handbag that probably cost more than my monthly car payment. But her carefully maintained composure cracked when I showed her the emails. She read through them twice, her face getting paler with each page. When she finally looked up at me, her eyes were wet with tears she was too proud to let fall. "How did you get these?" she asked, her voice barely above a whisper. I explained about finding the folder behind my filing cabinet, though I still could not figure out how it had gotten there in the first place. The papers had to have come from somewhere, but the origin did not matter as much as the content. Deborah pulled out her phone and started making calls. Within an hour, we had assembled an emergency meeting with Patricia, Victor, and Sandra at the same coffee shop. Victor was the first to suggest we were looking at legal malpractice and possibly fraud. He worked in cybersecurity and had a naturally suspicious mind, which served us well in this situation. He pointed out that Gregory had not just failed to disclose his conflict of interest. He had actively concealed it, billing us for work he never performed while sabotaging our case from the inside. That went beyond simple malpractice into potential criminal territory. Patricia, ever the voice of reason, urged caution. She reminded us that we needed to verify everything before we made any accusations, especially ones that could result in criminal charges. She was right, of course, but the evidence seemed overwhelming. Sandra suggested we hire a new attorney immediately, someone who could review our case and advise us on next steps. We all agreed that was the logical move, but finding a lawyer we could trust after this betrayal felt impossible. I volunteered to handle the research. My engineering background had taught me how to evaluate credentials, check references, and verify claims. I spent the rest of that day reaching out to attorneys across Phoenix, explaining our situation in vague terms to gauge their reactions. Most were sympathetic, but clearly wary of taking on a case that involved allegations against another lawyer. The legal profession protected its own, and nobody wanted to be the one who broke ranks. Finally, I connected with an attorney named Michael Chen who specialized in legal malpractice and conflicts of interest. He agreed to meet with us the following day at his office in downtown Phoenix. His receptionist warned me that he would charge $500 for the initial consultation, which seemed steep until I remembered we had already paid Gregory Walsh tens of thousands of dollars for the privilege of being stabbed in the back. Michael Chen's office was nothing like Gregory Walsh's. Where Gregory had favored expensive furniture and dramatic floor-to-ceiling windows, Michael worked in a modest space with functional desks and walls lined with law books. He was in his early 40s, wearing a simple button-down shirt and slacks, and he listened to our story without interrupting. We had brought copies of all the evidence, and he spent nearly an hour reviewing everything while we sat in uncomfortable silence. When he finally spoke, his assessment was even more damaging than I had feared. Gregory Walsh had not only violated his ethical obligations by representing both us and Hartfield Development Corporation, but his concealment of that conflict potentially voided every filing he had made on our behalf. Any motions, responses, or legal documents he had submitted to the court would need to be withdrawn and refiled by new counsel. The deadlines we thought we had met were meaningless. We were essentially starting from scratch, except now the development project had moved forward significantly while we had been spinning our wheels with a compromised attorney. Michael also confirmed that we had grounds for a legal malpractice suit against Gregory Walsh and potentially a fraud claim as well. The emails we had obtained showed clear evidence of deliberate deception and self-dealing. But pursuing those claims would take time and money, resources we had already depleted fighting the development. We were trapped in a nightmare scenario with no easy way out. Deborah broke down crying in Michael's office, something I never thought I would witness. The HOA president who ruled our community meetings with an iron fist and intimidated code violators into compliance was sobbing openly, asking how she could face the other residents after leading them into this disaster. Patricia put an arm around her shoulders while Sandra and Victor looked equally shell-shocked. I felt anger more than anything else, pure, burning rage at Gregory Walsh for his betrayal, at myself for not catching it sooner, and at the system that allowed this to happen. Michael must have recognized what I was feeling, because he leaned forward and spoke directly to me. "Marcus, I need you to stay focused. Anger is understandable, but it will not help us fix this situation. What will help is methodical action based on solid evidence and good strategy. Are you prepared to do that?" I nodded, forcing myself to take a deep breath and think clearly. Michael outlined our next steps. First, we needed to file a complaint with the State Bar of Arizona against Gregory Walsh, documenting his conflict of interest and ethical violations. Second, we needed to formally terminate his representation and demand a full refund of all fees paid. Third, we needed to hire new counsel immediately to take over our case against Hartfield Development, assuming it was not already too late. Fourth, we needed to notify all the residents of Riverside Meadows about what had happened, which would be the hardest conversation any of us had ever had. Michael agreed to represent us in the legal malpractice claim and help us find appropriate counsel for the development fight. His retainer was $15,000, which we did not have in the HOA account anymore. We had spent nearly everything fighting a battle that had been rigged from the start. Deborah said she would call an emergency board meeting to request another special assessment, but we all knew how that would go over. The residents had already paid once. Asking them to pay again after admitting we had been scammed would be political suicide. I offered to cover half the retainer myself, $5,000 that Elizabeth and I had been saving for a new roof. Elizabeth would be furious, but this felt more important. Victor immediately volunteered another $5,000, and Sandra reluctantly agreed to cover the remaining amount. We would figure out how to get reimbursed later, assuming we won anything from Gregory Walsh. The emergency HOA meeting was scheduled for the following Saturday evening. Deborah drafted a vague announcement about important legal developments, trying not to panic everyone before we could explain the situation properly. The days leading up to that meeting were some of the most stressful of my life. I kept working, going through the motions at my engineering job, but my mind was always elsewhere. Elizabeth tried to be supportive, but I could tell she was worried about our finances and our future in Riverside Meadows. Saturday arrived too quickly. The community center was packed with over 200 residents, more than I had ever seen at an HOA meeting. Word had spread that something significant was happening, and everyone wanted answers. The air conditioning struggled against the combined body heat, and the room felt oppressive before we even started. Deborah called the meeting to order at 7 o'clock sharp. Her voice was steady, but I could see her hands trembling as she gripped her notes. She started with the basics. We had hired Gregory Walsh to represent the HOA in our fight against the Hartfield Development Project. We had paid him substantial fees for his services, and we had recently discovered that he had been simultaneously representing Hartfield Development, creating a direct conflict of interest that compromised our entire case. The room erupted. People were shouting over each other, demanding explanations, asking how this could have happened. A man named Thomas Reeves stood up and accused Deborah of being complicit, suggesting she must have known about the conflict all along. That was absurd, but fear and anger made people look for villains, and Deborah was the most visible target. I stood up and raised my voice above the chaos. Everyone, please, let us explain everything before you jump to conclusions. We are all victims here, including Deborah. The crowd quieted slightly, and I took that as permission to continue. I explained how I had discovered the emails, what they contained, and what we had learned from Michael Chen. I showed copies of the most damaging correspondence on the projector screen, watching faces in the crowd shift from anger to shock to despair as they realized the full extent of the betrayal. A woman named Karen Whitfield stood up, and I suppressed a groan. Karen was exactly what her name suggested, a middle-aged woman with an aggressive blonde bob haircut who complained about everything from the shade of paint on garage doors to the height of backyard fences. She was the kind of person who called code enforcement on neighbors whose trash cans were visible from the street and demanded emergency board meetings when someone planted flowers she considered inappropriate. Now she had legitimate ammunition, and I knew she would make the most of it. "This is absolutely unacceptable," Karen announced, her voice dripping with righteous indignation. "We trusted this board to protect our interests, and instead you hired a con artist who stole our money. I demand the immediate resignation of every board member and a full refund of my special assessment fee." Other voices joined in, agreeing with Karen for once. The crowd was turning into a mob, and I could see Deborah's carefully maintained composure finally cracking completely. Victor tried to restore order, but nobody was listening to him either. It was Patricia who finally got everyone's attention by simply standing up and waiting silently until curiosity made people quiet down. "We made a mistake," Patricia said clearly. "We trusted someone who betrayed that trust, but dwelling on blame will not fix anything. What matters now is what we do next. Michael Chen believes we have strong grounds for legal action against Gregory Walsh. He also thinks we might be able to salvage our case against Hartfield Development if we act quickly, but we need everyone to work together instead of tearing each other apart." Her words had an effect, but Karen was not finished. "Easy for you to say when you are not the one who will be held responsible. The board needs to be replaced with people who actually know what they are doing. I nominate myself as interim president." Of course she did. Karen had been angling for a board position for years, constantly criticizing decisions without offering constructive alternatives. The idea of her running the HOA was terrifying, but I could see some people nodding in agreement. Desperation made even bad ideas look appealing. Michael Chen, who had been sitting quietly in the back of the room, stood up and identified himself. His presence immediately commanded respect in a way that none of us could manage. He explained the legal situation in terms everyone could understand, emphasizing that we needed stability and continuity to move forward effectively. Replacing the entire board in the middle of a legal crisis would only make things worse. "What you need right now is accountability and transparency," Michael said. "The current board should remain in place but under enhanced oversight. I recommend forming a resident oversight committee that will review all financial decisions and legal strategies going forward. That way you maintain institutional knowledge while ensuring no single person can make critical mistakes without being checked." It was a reasonable compromise, and the crowd seemed to accept it. Karen tried to object, but even her supporters could see the logic in Michael's suggestion. We spent the next 2 hours hammering out the details of the Oversight Committee, establishing procedures for transparency, and answering questions from angry, frightened residents who had just learned their home values were under threat, and their money had been stolen. By the time the meeting ended at 10 o'clock, I was emotionally and physically exhausted. Elizabeth had stayed home with the kids, and I was grateful she had not witnessed the ugliness of that gathering. I drove home in silence, replaying the evening in my mind and wondering how everything had gone so wrong. The next few weeks were a blur of activity. Michael filed the complaint against Gregory Walsh with the state bar, including all the email evidence and documentation of his dual representation. The bar took complaints seriously, especially ones involving clear conflicts of interest, and they opened an investigation immediately. We also sent a formal termination letter to Gregory, demanding a full refund of all fees paid and preservation of all documents related to our case. Gregory's response came through his own attorney, which should have been our first hint of how he would play this. He denied any wrongdoing, claiming that his representation of Hartfield Development had ended before he took on Riverside Meadows as a client. The emails we had obtained were, according to his attorney, taken out of context and possibly forged. He accused us of defamation and threatened to countersue if we continued making false allegations. The audacity was breathtaking. Michael assured us that Gregory's denials were standard defensive tactics and that the evidence against him was rock solid. But the threat of a countersuit was concerning, especially given our depleted financial resources. We could not afford another prolonged legal battle, particularly one that would drain money away from fighting the development. Michael had also been working on finding us new counsel for the Hartfield Development case. He connected us with a firm called Preston & Associates that specialized in land use and zoning litigation. The lead attorney, Jennifer Preston, was in her mid-50s with an impressive track record of representing homeowners against commercial developers. She agreed to review our case and met with the board the following week. Jennifer's assessment was sobering. Gregory had missed several critical deadlines, filed motions that were legally deficient, and failed to preserve important objections during preliminary hearings. The damage was extensive but not necessarily fatal to our case. If we acted aggressively and immediately, we might be able to salvage something. The key was proving to the court that Gregory's conflict of interest had prejudiced our case and warranted special consideration for missed deadlines. That meant we needed to make the conflict of interest public record, which would happen through the state bar complaint and through a motion to disqualify and void all of Gregory's filings. Jennifer warned us that this strategy would get ugly. Gregory would fight it because a finding of conflict would destroy his reputation and open him up to serious liability. But we had no choice. It was our only path forward. Jennifer's retainer was another $20,000. The board called another emergency meeting, this time with the new resident oversight committee present. I presented the financial reality. We needed money immediately, and our only options were either another special assessment or taking out a loan against the HOA's reserve fund. Both options were terrible, but doing nothing would guarantee we lost everything. Karen Whitfield objected strenuously to both options, arguing that we should just accept defeat and negotiate the best terms we could with Hartfield Development. Cut our losses, she called it, as if surrendering our neighborhood's character and property values was a reasonable cost-cutting measure. Several residents agreed with her, exhausted by the constant financial demands and legal drama. But most people wanted to fight. They had invested too much, both financially and emotionally, to quit now. A vote was called, and the special assessment passed by a narrow margin, $100 per household, due within 30 days. It was not nearly enough to cover everything we needed, but combined with carefully managed reserve funds, it would get us started. I spent the next month working closely with Jennifer Preston and her team, helping them understand our case and rebuild our legal strategy. The work was tedious and often frustrating, especially when we discovered just how thoroughly Gregory had sabotaged our position. But Jennifer was methodical and creative, finding angles that Gregory had either ignored or deliberately avoided. Meanwhile, the state bar investigation was progressing. An investigator contacted me to discuss the evidence we had submitted, asking detailed questions about how we had obtained the emails and what other interactions we had with Gregory Walsh. I told the truth about everything, including my uncertainty about how that manila folder had ended up behind my filing cabinet. The investigator seemed satisfied and mentioned that Gregory was not cooperating fully with their inquiries, which was apparently a separate ethical violation. 3 months after I found those emails, Michael Chen called with significant news. The state bar had concluded its preliminary investigation and determined there was probable cause to believe Gregory Walsh had violated multiple rules of professional conduct. They were moving forward with formal disciplinary proceedings, which could result in suspension or even disbarment. More importantly for our immediate purposes, their finding gave us powerful ammunition for our motion to void Gregory's filings. Jennifer filed the motion the next day, including the state bar's preliminary findings as an exhibit. She argued that Gregory's conflict of interest was so fundamental that it tainted every aspect of his representation. Any filings he had made on behalf of Riverside Meadows HOA should be considered void, and the court should grant us an opportunity to refile with competent, unconflicted counsel. She also asked the court to order Gregory to return all fees paid, though that was likely a symbolic request since the money was probably long gone. Hartfield Development opposed our motion vigorously. Their attorney, a shark named Richard Brennan from a major Phoenix firm, argued that we were simply trying to manufacture excuses for our own procedural failures. He claimed that even if Gregory had a conflict, we had not been prejudiced because the development project was legally sound and would have been approved regardless of opposition. He also pointed out that we had not discovered or disclosed the conflict earlier, suggesting we bore some responsibility for the situation. The hearing on our motion was scheduled for mid-October in Maricopa County Superior Court. Jennifer prepared extensively, conducting mock arguments with her colleagues and anticipating every possible objection from Hartfield's legal team. She wanted me to testify about discovering the emails in my subsequent investigation, so she spent hours preparing me for cross-examination. The morning of the hearing, I put on my best suit and met Jennifer at the courthouse at 8 o'clock. The building was imposing, all concrete and glass, and I felt a wave of nervousness as we went through security. Elizabeth had taken the day off work to be there for moral support, and several other board members came as well. Even Karen Whitfield showed up, though I suspected she was hoping to witness our defeat so she could say, "I told you so." Judge Raymond Foster presided over the hearing, a stern-looking man in his 60s with gray hair and reading glasses perched on his nose. He had a reputation for being no-nonsense and intolerant of games, which Jennifer thought worked in our favor. If we could present our evidence clearly and concisely, he would recognize the fundamental unfairness of the situation. Jennifer went first, laying out the timeline of Gregory's dual representation and the evidence of his deliberate concealment. She showed the court copies of the emails, explaining how they demonstrated ongoing communication between Gregory and Hartfield Development throughout the period he was supposed to be representing us. She highlighted specific instances where Gregory had made strategic decisions that benefited Hartfield at our expense, such as failing to object to procedural maneuvers that accelerated the development approval process. Then she called me to testify. I walked to the witness stand, raised my right hand, and swore to tell the truth. Jennifer's questions were straightforward, allowing me to explain how I had found the emails, what steps I had taken to verify them, and how the board had reacted upon learning about the conflict. I kept my answers focused and factual, resisting the urge to editorialize or express anger. Richard Brennan's cross-examination was aggressive, but not particularly effective. He tried to suggest I had somehow fabricated or manipulated the emails, but I had anticipated that line of attack. I explained the metadata, the verification steps I had taken, and the State Bar's independent investigation that had reached the same conclusions. He tried to argue that I should have discovered the conflict earlier by doing better due diligence before hiring Gregory, but that actually strengthened our case by highlighting Gregory's active concealment. After my testimony, Jennifer called an expert witness, a legal ethics professor from Arizona State University, named Dr. Ellen Morrison. Dr. Morrison explained the rules of professional conduct regarding conflicts of interest and why Gregory's behavior was such a serious violation. She testified that the conflict was not just a technical error, but a fundamental breach of fiduciary duty that corrupted the entire attorney-client relationship. When an attorney secretly represents both sides of a dispute, every action they take is suspect, and there's no way to know which client they were serving at any given moment. Brennan tried to undermine Dr. Morrison's testimony by suggesting that conflicts happen all the time and courts do not typically void filings because of them. But Dr. Morrison was well prepared, distinguishing between conflicts that are disclosed and managed appropriately versus conflicts that are concealed and exploited. Gregory's situation fell squarely in the latter category. Hartfield Development presented their own arguments, emphasizing the prejudice that would result if the court voided all of Gregory's filings. They argued that the development project had proceeded in good faith, obtaining all necessary approvals and making substantial financial commitments based on the legal landscape as it existed. Resetting everything would cost them millions of dollars and unfairly punish them for Gregory Walsh's misconduct. Jennifer countered that Hartfield could not claim good faith when they had knowingly worked with Gregory to undermine our representation. The emails showed clear coordination between Gregory and Robert Kincaid at Hartfield Development. They were not innocent victims of Gregory's ethical lapses. They were active participants in a scheme to deprive Riverside Meadows residents of effective legal representation. Judge Foster asked tough questions of both sides, clearly troubled by the situation, but also concerned about the practical implications of the relief we were seeking. He took the matter under advisement, saying he would issue a written ruling within 30 days. We left the courthouse with no clear sense of which way he would rule, though Jennifer thought our chances were reasonably good. The waiting was excruciating. Every day I checked the court's online docket, looking for any sign of a decision. The residents of Riverside Meadows were getting impatient too, constantly asking for updates that I could not provide. Karen Whitfield used the uncertainty to push her narrative that we should have settled early and avoided all this drama. She was gathering support for a recall vote on the board, and while I did not think she had enough backing yet, the longer things dragged on, the more persuasive her arguments became. 26 days after the hearing, Judge Foster's ruling appeared on the court docket. It was 48 pages long, single-spaced, and I started reading it immediately despite being at work. My hands were shaking as I scrolled through the detailed findings of fact and conclusions of law. Judge Foster had ruled in our favor on almost every point. He found that Gregory Walsh had engaged in serious professional misconduct by concealing his dual representation. The evidence of his ongoing coordination with Hartfield Development while purporting to represent Riverside Meadows was clear and convincing. The conflict was not merely technical, but fundamental, going to the heart of the attorney-client relationship and compromising every aspect of Gregory's representation. Most importantly, Judge Foster voided all of Gregory's filings on behalf of Riverside Meadows HOA and granted us 60 days to refile through new counsel. He also ordered Gregory Walsh to return all legal fees paid by the HOA, finding that he had obtained the money through fraud and misrepresentation. The judge stopped short of imposing criminal sanctions, noting that such matters were better left to the state bar and potentially the county attorney's office, but his ruling made it clear that Gregory's conduct was indefensible. I called Deborah immediately, and for the first time in months I heard genuine joy in her voice. We had won a major victory, not just in the legal sense, but in vindicating our decision to fight rather than accept defeat. Jennifer Preston was thrilled with the ruling, calling it one of the strongest findings she had seen in a conflict of interest case. The decision would give us a fresh start and real opportunity to oppose the Hartfield Development Project effectively. But we still had work to do, and quickly. Jennifer and her team had already prepared new filings based on various scenarios, and they immediately set to work adapting them to the specifics of Judge Foster's ruling. We had 60 days to catch up on months of lost time, which meant long hours and intense coordination. The HOA called a meeting to share the news with residents. This time, the atmosphere was completely different from that angry gathering months earlier. People were celebrating, applauding, and thanking the board for persevering through such a difficult situation. Even Karen Whitfield seemed subdued, unable to argue with such a decisive victory. She made a few comments about being concerned over ongoing costs, but her heart was not in it, and nobody paid much attention. I felt vindicated, but also exhausted. The past few months had taken a toll on my health, my marriage, and my peace of mind. Elizabeth had been incredibly patient, but I knew she was ready for life to return to normal. Our kids had barely seen me during this period, and I had missed baseball games, school events, and regular family dinners. Winning felt good, but it came with a cost that could not be measured in dollars. Jennifer and her team filed new motions opposing the Hartfield Development Project, this time with full knowledge of the zoning issues, environmental concerns, and procedural irregularities that Gregory had either ignored or deliberately failed to pursue. The new filings were comprehensive and aggressive, making arguments that actually had teeth. Hartfield Development suddenly found themselves facing real opposition instead of the token resistance Gregory had provided. Meanwhile, Gregory Walsh was dealing with consequences. The state bar accelerated their disciplinary proceedings based on Judge Foster's findings, and within 2 months they suspended his license to practice law pending a full hearing. The suspension effectively put him out of business, and his firm began dissolving as other attorneys fled the taint of association. Local media picked up the story, running articles about the lawyer who had betrayed his own clients to serve a developer. Gregory's reputation was destroyed, exactly as he deserved. Michael Chen also moved forward with our legal malpractice and fraud lawsuit against Gregory. Judge Foster's ruling made the liability case straightforward. The only question was damages. Michael argued we were entitled to full reimbursement of all fees paid, compensation for the diminished value of our properties due to delays in fighting the development, and punitive damages for Gregory's willful misconduct. The total claim exceeded $500,000. Gregory's personal assets were limited, but he had professional liability insurance that covered at least some forms of malpractice. Michael filed claims against the insurance company, which initially tried to deny coverage on the grounds that fraud was excluded. But Michael argued persuasively that even without the fraud, Gregory's simple negligence and conflict of interest were covered perils. Eventually, the insurance company agreed to settle for $250,000 rather than risk a trial that could result in even higher damages plus their own legal fees. The settlement money went into the HOA's accounts, reimbursing residents for both special assessments and creating a reserve fund for ongoing legal expenses. It was not complete compensation for everything we had endured, but it was meaningful justice. More importantly, it sent a message that attorneys who betrayed their clients would face serious consequences. The fight against Hartfield Development continued for another 8 months. Jennifer Preston and her team systematically dismantled the approvals that Gregory had allowed to proceed unchallenged. They identified environmental impact assessment deficiencies, traffic study errors, and zoning variance applications that had not followed proper procedures. Each issue became a separate legal battle, and Hartfield Development found themselves constantly defending decisions they had thought were final. The cumulative effect was devastating to their timeline and budget. Commercial development projects depend on careful scheduling and financing, and delays cost enormous amounts of money. Hartfield Development had borrowed heavily to finance the project, and every month of delay meant more interest, more holding costs, and more pressure from their lenders. 6 months after Judge Foster's ruling, Hartfield Development approached us about settlement negotiations. They proposed a significantly scaled-down project that would maintain more distance from our residential community, include substantial landscaping buffers, and commit to traffic management measures. They also offered to fund improvements to Riverside Meadows common areas and contribute to our schools as a form of community benefit package. The HOA board met with Jennifer Preston to discuss the offer. She thought it represented a genuine victory, achieving most of what we had wanted from the beginning. The revised project would have minimal impact on our property values and quality of life, while the community benefit package would actually improve things. She recommended we negotiate further on specific terms, but accept the basic framework. We presented the settlement proposal to residents at a packed meeting in March. Karen Whitfield objected, naturally, arguing that we should hold out for complete cancellation of the project. But her position was unrealistic, and most residents recognized that. Hartfield Development owned the land and had the right to build something on it. The question was what they would build and under what conditions. The settlement offered reasonable answers to both questions. After heated debate, the membership voted to authorize the board to negotiate final settlement terms. It took another 2 months to hammer out all the details, with Jennifer expertly managing the process. The final settlement agreement was signed in May, almost exactly 2 years after we had hired Gregory Walsh and started down this complicated path. Hartfield Development agreed to build a much smaller commercial complex with strict architectural guidelines to complement rather than clash with the residential neighborhood. They committed to extensive landscaping, traffic calming measures, and restricted hours for deliveries. They also paid Riverside Meadows HOA $300,000 for community improvements, which we used to upgrade our playground, resurface the community pool, and improve walking trails throughout the neighborhood. The legal battle had cost us dearly in time, money, and stress, but in the end, we had achieved a meaningful victory and protected our community from a development that would have destroyed our quality of life. More importantly, we had held accountable an attorney who had betrayed his clients for personal profit. Gregory Walsh faced his state bar disciplinary hearing in June. I attended as a witness along with Deborah and Michael Chen. The hearing was formal and procedural, but the outcome was never in doubt. The bar presented overwhelming evidence of Gregory's misconduct, including Judge Foster's findings, the email evidence, and testimony from several experts. Gregory's attorney tried to mount a defense based on misunderstandings and communications failures, but nobody believed him. The state bar panel deliberated for less than an hour before returning with their decision. Gregory Walsh was disbarred, effective immediately. He would never practice law again in Arizona, and the disbarment would likely prevent him from being admitted in other states as well. His career was over, his reputation destroyed, and his professional identity erased. I felt satisfaction watching Gregory's face as the decision was read. He had gambled that he could serve two masters and profit from both, and he had lost everything. Justice was not always swift or certain, but in this case, it had been thorough. The county attorney's office also reviewed the case for potential criminal prosecution. After extensive investigation, they decided to file charges for fraud and theft by deception. Gregory had obtained money from Riverside Meadows HOA under false pretenses, claiming he would represent our interests when he was actually working for the opposing party. That met the legal definition of fraud under Arizona criminal statutes. The criminal trial took place the following September. I testified again, as did Deborah and several other board members. The prosecution presented the same evidence that had been so effective in the civil proceedings: the emails, the dual representation, the concealment, and the financial harm to our community. Gregory's criminal defense attorney tried to argue that civil malpractice should not be criminalized, but the judge instructed the jury that fraud was fraud, regardless of whether it occurred in a legal services context. The jury deliberated for 2 days before finding Gregory Walsh guilty on all counts. The judge sentenced him to 5 years in state prison with the possibility of parole after 18 months. He also ordered restitution in the amount of the original legal fees paid, though that was largely symbolic since we had already recovered money through the civil settlement. Watching Gregory being led away in handcuffs, I felt a complex mix of emotions: relief that justice had been served, anger over everything he had put us through, and a strange sort of pity for a man who had thrown away his career and freedom for what in the end was not even that much money. The amount Hartfield Development had paid him for his betrayal was less than $200,000 according to evidence presented at trial. He had sold us out cheaply. Life in Riverside Meadows gradually returned to normal after the settlement. The commercial complex was built according to the agreed specifications, and while nobody loved having it there, it was not the disaster we had feared. Property values stabilized and even increased slightly, helped by improvements we had made with the settlement money. The neighborhood looked better than it had in years, with new landscaping, fresh paint on common buildings, and well-maintained amenities. Deborah Mathens announced she would not seek re-election as HOA president, saying she had earned a break after the most tumultuous period in the community's history. Patricia Coleman ran for the position and won easily, bringing her calm temperament and good judgment to leadership. Victor Hayes and Sandra Mitchell remained on the board, providing continuity and institutional knowledge. I stepped back from active involvement in HOA governance, ready to focus on my family and career again. Elizabeth and I took a long vacation, just the two of us, leaving the kids with their parents for a week. We did not talk about HOAs, lawyers, or property development. We just reconnected as a couple and remembered why we had chosen to build a life together. Karen Whitfield continued to complain about various issues because that was simply who she was. But her complaints carried less weight after being so consistently wrong about the major issues. She objected to the paint color chosen for the community center, the rules about holiday decorations, and the fee structure for pool memberships. People listened politely and then ignored her, as they always should have. Looking back on everything that happened, I recognize how easily it could have ended differently. If I had not found those emails, we might have continued trusting Gregory Walsh until it was too late to salvage anything. If we had not been willing to fight despite the costs and criticism, Hartfield Development would have built their original project and destroyed our neighborhood. If Judge Foster had been less willing to recognize the fundamental injustice of the situation, we might have been stuck with Gregory's sabotaged legal work. We had been lucky in many ways, but we had also been persistent. We had refused to accept defeat when defeat seemed inevitable. We had trusted the legal system to recognize truth and enforce ethical standards, even when that trust seemed naive. And we had worked together as a community, overcoming internal divisions and external threats. The manila folder that started everything still sits in my filing cabinet, a reminder of how fragile our institutions can be when corrupt people exploit them. I never did figure out exactly how it ended up behind the cabinet that night. Maybe it had fallen there by accident weeks earlier, and I simply had not noticed. Maybe Elizabeth had been reviewing documents for me and dropped it without realizing. The origin did not matter as much as what we did with the information once we had it. Riverside Meadows survived the crisis and emerged stronger. Our HOA became a model for other communities facing similar challenges, demonstrating the importance of oversight, transparency, and willingness to fight for what matters. Jennifer Preston used our case as an example in presentations to other homeowner associations, teaching them how to protect themselves from conflicts of interest and legal malpractice. Michael Chen built a thriving practice representing clients in legal malpractice cases, using the experience he gained from our situation. He became something of a specialist in conflicts of interest, helping other victims hold corrupt attorneys accountable. He sent us an annual holiday card, thanking us for trusting him when trust seemed impossible. As for Gregory Walsh, I heard through Michael that he was released on parole after serving 20 months of his sentence. He moved to another state, presumably trying to rebuild some semblance of a life after losing everything. I did not follow his progress too closely, because at some point you have to let go of anger and move forward. He had paid a heavy price for his actions, and dwelling on it served no purpose. My family thrived in the years after the crisis. My son graduated high school and went to Arizona State University to study business. My daughter discovered a passion for environmental science, ironically inspired by the environmental impact debates during our fight against Hartfield Development. Elizabeth got another promotion and now managed her entire department. I remained in my engineering job, finding satisfaction in the precision and predictability of technical work after years of legal chaos. The Riverside Meadows community continued to evolve. New families moved in, attracted by the reasonable HOA fees, well-maintained facilities, and reputation for effective governance. Longtime residents shared stories about the great legal battle, each retelling adding new details and embellishments until the history became legend. Karen Whitfield's opposition became more dramatic, Gregory Walsh's betrayal more villainous, and our eventual victory more triumphant with each version. But at its core, the story remained true. We had discovered that our attorney was secretly working for the developer we were fighting. That conflict of interest had voided his work and nearly destroyed our case. But we had persisted, found honest representation, exposed the fraud, and ultimately achieved justice. It was not a perfect victory, and it came at significant cost, but it was real and meaningful. I sometimes wonder what would have happened if I had simply gone to bed that night instead of pulling out the filing cabinet. The manila folder might have stayed wedged behind there for years, slowly yellowing and forgotten. Gregory Walsh would have continued his deception until our case collapsed completely. Hartfield Development would have built their massive commercial complex right against our neighborhood boundaries, and property values would have plummeted. The residents of Riverside Meadows would have blamed the HOA board for failing to protect them, never knowing that we had been deliberately sabotaged from the inside. Instead, we got the opportunity to fight back with full knowledge of what we were facing. That knowledge came with its own burdens, but it also gave us power. We could make informed decisions, take appropriate action, and hold the right people accountable. In the end, that made all the difference. The legal system worked the way it was supposed to work, at least eventually. Judges recognized injustice and corrected it. The state bar enforced ethical standards and removed a corrupt attorney. Criminal prosecutors held a fraudster accountable for stealing from his own clients. It was slow, expensive, and frustrating, but the system ultimately delivered justice. I learned lessons from the experience that extended far beyond homeowner associations and property development. I learned to trust but verify, to question inconsistencies, and to persist even when outcomes seemed uncertain. I learned that institutions are only as good as the people running them, and that corruption can hide in the most unexpected places. I learned that communities are strongest when they work together toward common goals, overcoming petty differences to focus on what truly matters. Most importantly, I learned that ordinary people can make a difference when they refuse to accept injustice. I was just an engineer who happened to be paying attention at the right moment. I was not a lawyer, investigator, or professional activist. I was simply someone who cared about his community and was willing to do the work necessary to protect it. That turned out to be enough. Riverside Meadows today is a pleasant suburban neighborhood outside Phoenix, Arizona. Children play in well-maintained parks. Families gather at the community pool on hot summer evenings. Neighbors wave to each other during morning walks, and the HOA board meets monthly to discuss mundane issues like landscaping contracts and budget allocations. It is ordinary in the best possible way, the kind of stable, comfortable community people dream about when they think of suburban life. But those of us who lived through the crisis know the truth. Ordinary communities stay ordinary through constant vigilance and occasional extraordinary effort. We fought to preserve what we had, and we won. The victory was not given to us. We earned it through persistence, courage, and refusal to surrender to corruption and dishonesty. Years later, I still drive past the Hartfield Development Commercial Complex on my way to work. It is smaller than originally planned, with extensive landscaping that actually complements our neighborhood. The buildings are well designed, the traffic is manageable, and the business tenants are good neighbors. It exists because we forced Hartfield Development to compromise rather than allowing them to do whatever they wanted. Every time I see it, I feel a quiet sense of pride. The manila folder that started everything still sits in my filing cabinet, though I have not opened it in years. It is simply there, a tangible reminder of the night everything changed. Sometimes I think about throwing it away, but I never quite do. Maybe someday my kids will find it and ask questions, and I will tell them the whole story. Or maybe it will just stay there, gathering dust, a silent witness to the time their father helped save a neighborhood from betrayal and corruption. Either way, the story itself is complete. We discovered the conflict of interest, exposed it, fought through the consequences, and ultimately achieved justice. Gregory Walsh went to prison. Hartfield Development was forced to compromise. Riverside Meadows survived and thrived. The legal system worked, the good guys won. It took 2 years, cost hundreds of thousands of dollars, and caused immense stress and anxiety. But in the end, we protected our community and held corrupt people accountable. That is all you can really ask for. A chance to fight, the tools to win, and the determination to see it through to the end. We had all three, and we made the most of them. The rest, as they say, is history.